Okay, welcome back. Our next panel is called COVID-19 1 year later. It is the version episode 2 of last year's COVID-19 What in the World's Going On panel. Very fortunate to have Kaz Hashemi with us today as the moderator. Kaz is the chair of the litigation department at Wilson Sonsini, and he has represented companies and boards in over 100 SEC government and internal investigation matters during his career. Kaz is also a veteran of the SEC Enforcement Division, and he's now been at Wilson Sonsini for over 15 years, where he's built a global and multifaceted SEC enforcement practice. Kaz, always great to have you with us. Welcome.
Thanks, Bruce. Glad to be here.
Next, I'd like to introduce Jason Lee. He is a member of the SEC staff, assistant regional director, and a member of the public finance abuse unit in the enforcement division in San Francisco and their regional office there. Jason spent some time at a big law firm. Now he's rising quickly through the ranks at the SEC, and always great to hear from Jason at this conference. Welcome, Jason.
Hi, Bruce. Thanks for having me.
I'd like to introduce Dr. Jennifer Marietta-Westberg. She is a principal at Cornerstone Research, where she consults on economic and financial issues arising in litigation and regulatory investigations. Jennifer's practice focuses on allegations related to financial reporting, asset management, trading, private equity, and mergers and acquisitions. Jennifer previously worked for 10 years at the SEC, including as the deputy chief economist and the deputy director of the Division of Economic and Risk Analysis. Welcome, Jennifer. Always great to get your perspective.
Thanks, Bruce. Happy to be here.
And finally, I'm pleased to introduce Ashley Baynham. Ashley is a partner at Rudnick, where she represents some of the world's leading companies and their executives in DOJ and SEC matters. Her focus is on white-collar criminal defense, securities enforcement actions, and complex commercial litigation. Ashley, it's great to have you with us. Welcome, and look forward to hearing from you today.
Thank you.
All right, Kaz, let me turn it over to you.
All right, Bruce. Thank you for setting this up again, and thank you all for joining us today. We have the COVID-19 panel 1 year later. When the pandemic started, there were a lot of unknowns in every aspect of our lives. On the work front, and specifically SEC enforcement and investigation matters, I think everyone had a lot of questions. How is remote working going to impact investigations generally, from the tasks of document preservation, collection, and production, to preparing and defending witnesses and testimony, to the substantive interactions we normally have with the staff during an investigation, whether it's proffers, pre-wells, wells, white papers, and how is the staff going to address sensitive issues raised by COVID-19 related issues? What types of cases will they pursue? And personally, I was quite skeptical of how it all would work. I thought witness preps and testimony were going to be much more challenging, and I also thought virtual practice could impact the quality of legal services our client deserves. And unfortunately, the work has continued virtually in a way much better than I originally anticipated. And I say unfortunately because I generally like human interactions, and we've been able to do it with very little of that. Personally, I've prepared and defended witnesses in SEC testimony and private lawsuits, and done all the other stuff like proffers and pre-wells meetings. And we have a great panel to discuss whether this is the new norm moving forward. And let's start with our senior enforcement panelist, Jason. Jason, you and I were on this panel a year ago, and we were wondering how this would all play out. So how did the SEC shift its investigation procedures in light of the work at home orders? What happened?
Yes, first of all, Kaz, you talked about how you like human interactions. I feel like I've still had human interactions for the last 14 months professionally, just via computer screen. And you kind of alluded to this, but slowly it's gotten to feel a little more normal, a lot more normal actually. So just really quickly, quick disclaimer that the views I express today are my own and do not necessarily reflect those of the SEC staff, the commissioners of the SEC, or the agency. So just generally speaking, I'd say that just like everyone else, after the COVID pandemic hit in earnest last March, the enforcement staff had to go pretty much completely remote And we've been in that status ever since, which takes us now to well over a year. The process has necessitated flexibility and ability to adapt, as I'm sure everyone on this panel and in the audience is well aware. But at least from my perspective, I feel like things have worked out pretty well. And I think that's in line with what your general sentiments, Kez. While in some ways, I feel like things are very different from the ways they were pre-pandemic, at core, they are fundamentally the same. So just speaking from my perspective, we're still pretty much doing all the same things that we did prior to the pandemic and the work from home orders. We're receiving and vetting tips, referrals, and complaints. We're still monitoring the market for potential misconduct, and we're still opening investigations and pushing them forward. So that's issuing document requests, taking testimony, interviewing witnesses, engaging the Wells process, participating in proffers and counsel, meetings with counsel like yourself, bringing enforcement actions, litigating those actions. So I'm part of the Public Finance Abuse Unit in the Division of Enforcement, and a team of unit members, as well as group folks from the trial unit, even prosecuted and won a virtual bench trial in the Southern District of New York last year. So I think we were all a little bit, it was such a shock last year when we talked. And I think there was just a lot of uncertainty. But as it became clear that, we're going to have to adjust because the circumstances weren't going to change anytime soon, I feel like not just the staff, but my sense is that witnesses I've interacted with and counsel as well have all reacted and adjusted. And this really is sort of a new normal for now. It'll be interesting to see from everyone's perspective how things kind of move forward in the future. I just say once again that I think that the caveat is that, nothing's perfect, but I think if everyone has the right patience and is flexible and is willing to work together, it's all worked out pretty well in my mind.
We'll get to the defense perspective in a second, but from your perspective, how do you think testimony, proffers, meetings with counsel, have they been as effective from your vantage point in this virtual environment as opposed to, meeting in person and taking testimony in person, hearing proffers in person, hearing arguments from counsel in person?
It's hard to say to make a perfect comparison, right? Because I think we're all biased in some extent too, in that all we were used to was how we conducted business prior to last March. But what I would say is that I have found the process to be effective. I don't know if on the margin there might be areas where there's actually advantages to doing things virtually, or there are disadvantages. And there's obviously disadvantages in the sense that someone can't log into the WebEx on time, or the court reporter just can't get on, or the video doesn't work, things like that, right? And that's what I was alluding to in terms of the patience and flexibility. But in terms of, just from my view, taking testimony from a witness, hearing from him or her, assessing them, gathering the information, I feel like it's worked out well and been pretty effective. And certainly I feel like proffers and meetings have been effective as well. In a lot of ways, some meetings that might have just been by phone before, we're doing more by video now, and in that sense creates a little more rapport than even what might have done in the past.
Right. Ashley, from a defense perspective, what have been some of the challenges and the nuts and bolts of investigations, some of the things that Jason just spoke about?
It's evolved over the years. So I think at the beginning of the year, at the beginning of the pandemic, we were sort of the defense bar, including myself, was less likely to bring in a client for sworn testimony than sort of later on in the year. So I think it was finding creative ways to sort of respond to investigative requests, short of offering more attorney proffers or more detailed attorney proffers, or doing video interviews where it wasn't necessarily on the record in the beginning, depending upon whether the staff was okay with that or not. But I think the biggest challenge has been, I think the testimony or the meetings with the SEC or with other government agencies has gone well. I would agree with Jason on that. I think where it's been more challenging is the sort of communication with your client. So being able to be in the same room with your client in preparation of the testimony, putting the documents in front of them and having that human sort of face-to-face interaction. I've had certain clients who really, because of the particular sensitivity of the matter, wanted us to be in person. Luckily, that was in sort of the second half of the year. So we've met in some creative venues. So finding a venue that has a lot of air ventilation and has, doors that you can prop open, or that you can sit outside. So I've done some prep for clients outside where we sat outside wearing a mask because it felt like that was a more comfortable situation. So I do think there are, in many cases, the clients, if it's a particularly sensitive matter, wanted their attorney by their side and didn't feel that it was the same to do it virtually. And so that is something that I think will start going back to normal. And I've already seen it go back to normal. So getting requests from clients, are you fully vaccinated? If so, are you comfortable getting on a flight to come to me to my location? So even if the testimony is still going ahead virtually, I'm now finding myself starting to travel more often and be physically with my client, both in preparation and during the testimony itself. And I do think that aids for a better sort of testimony. So if there's a need to consult over a privilege issue or something in the middle of testimonies, it's much easier to do that than to figure out a virtual breakout room, because I think that presents its own challenges of sort of going in and out of the technology. And so I think going forward, I think you're going to see sort of a calibration. I think people are going to continue using some of these virtual methods. So this wasn't SEC, but I did a third-party deposition last week. My client was a relatively, didn't have a lot of facts for the case. The entire deposition was an hour. And I see in situations like that, clients are not going to want to pay for people to travel for an hour-long deposition. And so I think in those instances, people will continue to use the virtual methods that they've been using thus far. But I think in other cases, we're going to start picking up the travel again to have those sort of in-person interactions and in-person prep with your clients.
And what about, in my experience, I did notice a difference in the interactions with the staff on whether it was a proffer or making, arguments through a pre-Wells meeting with the staff. I always have done it in person in most instances. I don't know if I could say it was less effective or anything. It was definitely different. Did you notice in those kind of interactions, whether afterwards thinking it would have been better if we were in person, going through a proffer or a pre-Wells meeting or a Wells meeting or an argument that you were making on behalf of your client?
I think it was harder to gauge the reactions. So I think the presentation was the same, but sort of getting those sort of interactions and the formal when you're taking breaks and before the meeting and after meeting, really sort of missed those interactions to gauge, are they following? Are they getting along? Are they smiling? When you're in a break, you definitely missed that sort of interactions of, are they going along with me or not? And so sometimes I just scheduled follow-up calls, now that you've synthesized this information, do you have further questions? But I do think it did sort of lead itself to, you didn't always know how some of your arguments were landing, because you didn't have that sort of informal 15 minutes or 10 minutes as you're sort of, as the staff member sort of walking you out, telling you, after the meeting has concluded.
Right. You just clicked on and you just started talking. So that was Jason, how about from your perspective, those substantive interactions? Did you feel like it was impacted by the virtual environment when counsel was presenting to you?
I honestly don't. I feel like the first few months or whatever, the initial period where people were reacting, not just professionally, but your own personal life in terms of health concerns and family situation, everything just felt different and off, and to some extent, right? But I feel like at this point, for me at least, I feel like the communications have still been effective. And as Ash was alluding to, I think I know myself, I've done this, and I think others have too. You just have to be more flexible. So if someone wants to call me up afterwards or have more discussions in different ways, I'm willing to do that, basically to, in some ways, compensate for the fact that the process is different than it used to be. So I think in the aggregate, to me, it's still been pretty effective.
Okay, great. So let's go to some substance now. How would you compare the enforcement activity generally? And then can you walk us through different types of COVID-related enforcement actions over the last year? I think our audience would appreciate that.
Yeah, sure. So I think that, and I've said this a couple of times, and it's not like rocket science. The first couple of months, everybody was there's a lot of uncertainty. And so I think a lot of people were adjusting to changes in their lives, changes to work, trying to plot forward as responsibly and quickly and efficiently as possible. But, we didn't know how long the pandemic would last per se. And there was a lot of feeling things out. That said, I think fairly quickly, the enforcement staff kind of got reorganized and got together and started plotting forward. And ultimately had a pretty productive year. I think for fiscal year 2020, the SEC still managed to bring a pretty diverse mix of over 700 enforcement actions that covered essentially the same broad range of actors and charges as in the prior years. And just as one more data point, like through those actions, the commission obtained judgments and orders totaling $4.68 billion in disgorgement and penalties, which was a record amount for the commission. So, there was certainly like an adjustment period, but I think pretty quickly things kind of got back to normal, or to the new normal, with the continued ramp up. In terms of types of cases, I want to say that first of all, there would continue to be the same type of regular cases that staff looked into, but yeah, there were definitely COVID specific issues that popped up that impacted, from my perspective, what I was seeing in enforcement, some of the investigative work we were doing, and ultimately some of the actions that have become public that we've brought. So the first thing, which we actually discussed last year a bit during last year's forum, was that after the pandemic hit, the commission was pretty quick in investigating and issuing a variety of trading suspensions where there was some nexus to COVID-19. And I don't want to, those are all on the SEC website, and we covered this last year. But just at the highest level, how did the information that led to some concerns that led to the trading suspensions relate to COVID? Some of it was about statements about an issuer's purported ability to obtain, PPE, so like personal protective equipment, N95 masks, as we all think back to that issue. There was misinformation out there about issuers' ability to develop COVID-19 test kits, again, tying to a hot issue in the country in terms of, the need for more testing. All the way to information out there that there were concerns about the accuracy about relating to COVID-19 preventative products or treatments. I think there was even one action about, purported cedar leaf oil treatment for COVID-19 and the impacts on, I think in that case, a microcap stock or microcap security. So what you saw was a bunch of quick action there on the part of the commission related to trading suspensions, trying to keep some stability in the market, protect some investors. And then what I can talk about now from then is that there's been a series of public enforcement actions that cover a range of topics, but I'll just sort of broadly cover three categories now, and just give a quick example. One would be actions against issuers and issuer officials for misrepresentations concerning COVID-related products. So again, like COVID tests, N95 mask availability. A second type of action has been pump and dump and other market manipulation schemes related to COVID-19. And then the third I'll touch upon quickly are actions involving misleading statements regarding the financial and operational impact of COVID on an issuer's business. So on the first topic, so sort of misreps about COVID products or COVID-related items. One set of examples I'll mention are SEC versus Mark Shana and SEC versus Marietta Corporation and Renee Shana. Those were filed as two separate actions in the Northern District of California, but relate to the same company, Marietta Corporation, and some of its executives. Basically, those matters involved alleged misleading statements about Marietta Corporation's development of a COVID-19 blood test. In short, the SEC alleged that Marietta and its president, Mark Shana, made a series of false and misleading statements, claiming that Marietta had a COVID-19 test before it even had components needed to make a test, claiming that Marietta's test was pending FDA emergency use authorization when an application for EUA had not even been filed, and claiming that Marietta had received more than 50,000 requests for its test and was coordinating with local, state, and federal agencies, which is again a claim that our complaint alleged was misleading, false and misleading. So essentially claiming sort of this legitimacy and strong demand for this test that the SEC alleged was false. The action against Mark Shana, so he's the president and actually the chief science officer of Array, is still pending, and it alleges violations of Section 10B of the Exchange Act and Rule 10b-5. The separate action against Array Corporation, the company itself, and Renee Shana, who is the former CEO of the company, was filed settled. And that complaint charged Renee Shana with aiding and abetting Array violations, including violations of 10B and Rule 10b-5, and also alleged that Renee Shana was liable as a control person of Array, pursuant to Section 28 of the Exchange Act. So that was a settled action, and in the settled final judgment, the former CEO, Renee Shana, obtained their injunctions, 3-year officer and director bar against her, and a $50,000 penalty. So that's just a couple examples about, enforcement action related to disclosures about COVID-related products. Real quickly about pump and dumps, market manipulation related to COVID. An example is SEC versus Jason Nielsen. It was filed in Northern District of California, and it's also related to Arrayet Corporation. So this was a non-insider of the company who essentially, on an online investment forum, pumped up the stock of Arrayet and ultimately sold at a profit after contributing to strong demand for the security. The misleading statements he made were varied, but essentially were about the supposed development of a COVID test at Arrayet, FDA approval of that test, and also statements that he and other investors were buying or intending to buy the security, so pumping up the stock. The SEC also charged Nielsen with spoofing. So I think many of you are familiar with that, but for those who aren't, essentially a manipulative scheme where the defendant allegedly placed a lot of orders and then subsequently canceled them right away, but did so in a way to try to prop up and create an illusion of demand for the security. So the last category I want to quickly highlight are public actions we've brought related to misleading statements about the impact of COVID on an issuer's operations and finances. So one of these is SEC versus Lewis Wallach, WALLACH, and that's in the Northern District of California and still pending. That matter involved a real estate investment scheme encompassing $330 million raised from more than 1,300 investors. It's not directly about selling, a COVID-related product. Ultimately, the complaint alleges that significant amounts of the new investor money was improperly used for Ponzi-like payments to pay back earlier investors, rather than its intended purposes for the real estate business. But this is an example where the COVID-19 pandemic exacerbated the alleged fraud that was already taking place. As incoming investor money slowed and investors began withdrawing their investments after the pandemic hit in March 2020. Also, the defendant, who was the president of the key entity at issue, allegedly made false statements in response to investor inquiries about the impact of COVID-19 on their investments by giving the false impression that the business was doing fine and had the financial resources to withstand the pandemic. So I wanted to highlight that as sort of one example of how it's still COVID related, but not necessarily about a COVID product.
Right. Okay. Well, thanks, Jason. And before we bring in Jennifer into this, Ashley, do you have any thoughts or from a defense perspective on some of the cases or the commission brought? I know Jason didn't get to the Cheesecake Factory, but any thoughts on those cases from your vantage point?
Yeah, so bringing up on the Cheesecake Factory, I think everyone sort of in the defense bar is looking to see if there's going to be additional sort of actions brought related to public company disclosures that have been made over the past year about the financial status of companies. So for those of you not familiar, there was a settled order in the beginning of December of 2020 in relation to the Cheesecake Factory. They settled regarding materially false and misleading statements that had been made in some of their 8Ks in March of 2020. What the commission focused in on was an inconsistency between their private statements and their public statements. So statements they were making, for instance, about their ability to make rent payments, as opposed to statements that they were making out to the public. So they ended up settling. It was not a fraud settlement, so it was a non-fraud settlement for about $125,000, which in the grand scheme of things is not huge. But the takeaway I think that people are seeing from the Cheesecake Factory case is that the SEC is delivering on its promise that it's scrutinizing public statements from companies to see if they're properly disclosing the risks related to the COVID-19 pandemic. That they're obviously going to focus on the disconnect between public and private statements. And one area where this may continue to come up is with PPP loan applications. So if a company is applying for a PPP loan application, and in that application making certain certifications about their financial status or their uncertainty about their financial status, and at the same time making rosier statements to the public. They're putting themselves at risk, those public companies, for additional scrutiny from the SEC. Obviously, they're more likely to focus on impacted industries like the Cheesecake Factory in the restaurant business, or, you know, if you're a Carnival cruise line or the like, more impacted industries are more likely to garner attention. But I thought it was interesting it wasn't charged as a fraud, and that it was a lower amount, which suggests that the SEC may be understanding that there are mitigating circumstances with some of these companies given the financial uncertainty and what they knew or didn't know about where their numbers were going at the time.
All right, thank you. And so let's switching gears a little bit, bringing Jennifer into this. Jennifer serves as the chair of the SEC Investor Advisory Committee. Why don't we start off with you giving us a little overview of the committee and its work generally?
That sounds great. So Dodd-Frank established the new, what was new at the time, Investor Advisory Committee. I'll use the acronym IAC for the committee. And it was established to advise the commission on really anything impacting investor protection or the integrity of the financial markets. So this could include advising or making recommendations on the commission's regulatory priorities, the regulation of securities products, disclosure effectiveness, and the recommendations that the committee makes are just that, they're recommendations. They are not binding. The committee is comprised of participants in the marketplace from a variety of areas who bring different perspectives and different expertise. And the commission has other advisory committees, not just the investor advisory one. There's also a committee on small business topics, one on asset management, and another on fixed income.
And how many folks are on the committee you chair?
Approximately 20. That ebbs and flows a little bit. There is a 4-year term. And so as people move off and on, sometimes we have a little bit more or a little bit less.
And how often do you interact with the commission and with your proposals?
So the IAC meets quarterly, and that's roughly calendar quarterly, but changes a little bit from year to year. The full commissioners, the full set of commissioners participate in these meetings as well. The meetings are public, so you can watch them live on the SEC website. The agendas are posted as well. If you miss the public meeting, the webcasts are also available.
Great. Well, thanks for that background. And then turning to the topic of today, the COVID-19, can you walk us through some of the COVID-19 related work the IAC undertook over the last year?
Yes, will do. So I think many people are aware through conversations like Jason has done today about the actions and the COVID committee that the commission set up. But there was also work between the commission and these outside advisory committees around COVID last spring. So Chair Clayton called 2 ad hoc meetings in the spring of the Investor Advisory Committee, again with participation from the full slate of commissioners, to understand in real time what were the members of the committee seeing. And so in those conversations that we had in those 2 meetings last spring, participants spoke about disclosure issues, whether there were market disruptions, impacts on things like retail investor trading. Were they able to get their broker on the phone? Were companies adequately disclosing the potential impacts of COVID on their operations and their future prospects? So I think this was a great move by Chair Clayton to really make sure that he was gathering input from all corners during that period.
Great.
I think that just a couple of other things to round this out. So following those meetings in the spring, the IAC did put a recommendation out in September for the commission to consider. This was related to going concerns and suggested that the SEC remind issuers about the relevant disclosure obligations. Also suggested that the SEC guide issuers and investors around audits and control assessments, given the unprecedented move to offsite operations for many companies. And then finally, in December last year, our entire quarterly meeting was devoted to COVID-19 issues. We had one panel focused on corporate disclosure. The panelists that we brought in talked about supply chain disruptions. We had an academic researcher who spoke about what he was seeing across a large number of filings related to disclosure information, the timing of those disclosures by companies, and the impact on different industries. And the other panel that we had focused on what are the implications for the next proxy season coming out of COVID, and again, those topics, disclosure, also executive compensation, non-GAAP reporting, and virtual shareholder meetings. So we do our best to try to stay abreast of the issues and to focus our quarterly meetings on those.
Were there any takeaways from the company disclosures, the analysis folks were doing on the company disclosures during the pandemic?
Yes, I think so. And we've done some of that work here at Cornerstone as well. So I think fairly rapidly, starting in February and March of last year, you started to see firms disclosing and referencing information about COVID. There was a very rapid ramp up in filings to the commission referencing COVID in not only March, but also then May, when you had the quarterly earnings season. You also saw a number of trading halts come out of that time. And I think one of the things that Chair Clayton focused on in these meetings was, are there new types of disclosures that firms may not be used to providing in their disclosures, but should think about this time? And so one example that he gave of that on our spring meeting was thinking about the firm's competitive position and how that may change if certain economies open up sooner than others. And so just really thinking through this different situation and not going through what you've done historically, but providing information, particularly forward-looking information. The SEC made a real push for that. So yes, as I said, and those webcasts are available as well if anyone would like to go back and look at them.
Very interesting, very interesting. You are an economist at Cornerstone. Switching gears a little bit, what are some of the ways that you've seen COVID-19 impact securities class action matters? That's one of the topics here is COVID-19 one-year letter, SEC enforcement, and private securities class action matters. From your vantage point, what have you seen as the impact from market efficiency, those kinds of issues?
Yes, so as we know, issuers can face parallel class action matters in relation to certain SEC enforcement actions. So there are issues not only relevant for COVID-related securities cases, but also all securities cases coming out of this COVID period. I think if you focus on the spring 2020 market turmoil, that will lead you to some particular economic implications. So one of those would be around the peak market turmoil in March of 2020. Potentially legitimate questions can be raised about whether the market was efficient during that time. A number of trading halts, as I mentioned, during that period, as well as price swings. So this will depend on the particular companies that you're looking at, but that is likely to be an area of focus for economists on these types of cases. And then also, as usual, you would be looking if there's potential confounding information. And some stocks could have reacted during that period of market turmoil to other factors such as monetary or fiscal policy developments and how those may have impacted company fundamentals. So those are at least two areas that would be important to look at across all class actions.
Any trends? I know Cornerstone tracks and any trends you see overall in class actions over the last year in terms of volume, types of cases? Any examples you want to share with us of specific class actions?
Yes, so if you're looking related to COVID, so we did not see a huge wave of cases, but we have seen even through this year, cases related to COVID that are being filed. So there have been about 28 specific actions filed with COVID-related allegations. 9 of those have come in 2021, so it's not as if they have stopped. The type of COVID cases that you saw filed initially were what you would expect with an exogenous event like this pandemic. Those initially, of course, were focused on specific industries like tourism and cruise lines. Other claims have been against health and pharmaceutical companies. So at a high level, I think the allegations include the normal types of things that tend to come up, with potentially companies understating or perhaps misrepresenting the impact that COVID could have on their business. We saw that with some of the cruise lines. We also saw that with potentially allegations of companies over-touting their products. And this is similar to some of the SEC enforcement actions that Jason walked through. And if you look at some of those early actions, I think everybody's aware that Norwegian Cruise Lines was one of the first actions filed in March of 2020. Those allegations were about the company misrepresenting the impact of the outbreak on their operations. Now, that case was dismissed just last month. And among other reasons, the judge concluded that many of the disputed statements were protected by the safe harbor for forward-looking statements. Other cases that were also filed around that time of March 2020, such as the one against Inovio Pharmaceuticals, is still alive. So the judge has allowed some of those allegations to proceed. And that was the allegation around the company saying that they had constructed a vaccine within 3 hours. And so some of that is still alive. And then finally, I think you're seeing some different types of actions now related to COVID. So in February of 2021, there was a matter brought against Tyson Foods. And that one, rather than being about solely about disclosures or about claims of technologies that you have to fight COVID, this one was about its factories, allegations of whether employees were protected, and then what that impact could be on the company's production.
Okay, thank you, Jennifer. Moving on, and I know you touched on this in the 7 minutes we have left, Ashley, on the Paycheck Protection Program. In April 2020, the Division of Investment Management issued guidance related to PPP loans. And so if you could tell us about that guidance and then the practical implications of it over the last year.
Yes, so as you said, the Division of Investment Management has a COVID sort of FAQ that they've issued. That particular COVID FAQ, there was a question about whether an investment advisor needed to disclose that they had received a PPP loan. The answer was a little, it depends, but more specifically, whether if the circumstances leading you to seek a PPP loan or other type of financial assistance constitutes a material fact relating to your advisory relationship with clients, it is the staff's view that your firm should provide disclosure of, for example, the nature, amounts, and effects of such assistance. They didn't further define the materiality of what would be material to an investment advisor, other than they gave an example. If you're requiring the assistance to pay the salaries of your employees, who are primarily responsible for performing advisory functions, it's the staff's view that you would need to disclose this fact. And so this put, I think, a lot of investment advisors who had received PPP loans into sort of a question about whether they needed to disclose it. I believe the number is about roughly 1,400 investment advisors received PPP loans. They took sort of a mixture of responses is sort of my understanding on this about whether they had to disclose it. And if it was just for administrative staff, they did not disclose it. And other instances where they did disclose if it did go to the specific example that the SEC gave. I think there had to be a balance struck here because there were certain sort of investment advisors who were worried if they disclosed that they were having financial troubles and receiving PPP loans, that it would have obviously a negative impact on their business. And so there was a lot of literature at the time about whether they can say they were doing this to be conservative and they weren't certain whether they would really need the PPP loan. But then that started running afoul of the certifications that you have to make to receive the PPP loan, that you're facing a certain level of uncertainty. So making certain your disclosures, the investment advisors, the disclosures that they made on the Form ADV were consistent with the certifications that they were making in their PPP applications about the financial uncertainty. And so I think we're waiting to see if there'll be some actions from the SEC sort of related to Form ADVs and then whether investment advisors sort of hit the right tone in making certain disclosures about their PPP loans. I do know that as forgiveness applications are going in, there has been some literature sort of in investment advisors sort of magazines that some of them are just going ahead and voluntarily repaying their PPP loans in order to sort of minimize their exposure. So some of them are making public statements that they applied for the PPP loans in March and April when they thought things were going to be worse than they ended up being. They ended up holding the money, not needing it for the approved uses, and are now repaying it to the government. And so I think the number of investment advisors who are that'll obviously decrease the number of investment advisors who may be at issue for not disclosing or having a disconnect between their disclosure and their Form ADV and their PPP loans. So I think it's a tricky issue, and there's a second round of PPP loans that opened up in December of 2020. So it's an ongoing discussion about what has to be disclosed, and I think it really gets to whether it's the need for the PPP loan is going to sort of the heart of your business, and it's going to affect your advice as to whether you have to disclose it. I would say sort of roundabout with all of these PPP loans, when you're talking government enforcement agencies, there's a fair bit of concern that there's hindsight bias. So the SBA in their questionnaire for audits is asking a lot of questions related to, well, did you end up doing capital improvement projects? What was your gross revenue at the end of the year? And so I think a lot of companies are in a position, or investment advisors or public companies, of, well, in March and April, we thought we needed the loan because we didn't know how we were going to do. We may have ended up doing better, but we still use the money in appropriate ways. So we should get the forgiveness. And so I think there's a little bit of uncertainty about what's going to happen to some of these companies.
Got it. Jason, any views from an enforcement perspective on what Ashley just covered?
Hi, Puppy.
Yeah, I don't know that I have any particular strong views. I think that situations like this are always going to be case specific, in fact, and circumstance specific. I just think about the Cheesecake Factory case, for example,
Hey, Zach,
where, you know,
any way you can take him down?
Oops, you're someone's talking loud. We can hear you. Go ahead, Jason. Zach.
yeah, no problem.
Sorry.
Yeah, no problem.
It's okay.
No, I've been there. We've all been there.
Yeah.
I was just gonna say, I think your question, it really comes down to case by case facts and circumstances, sort of what's going on in the minds of the folks and whether they're acting in good faith. And all I was going to say is I just bring up the Cheesecake Factory example, where, you know, at the end of the day, it's a 13A11, I think, and a 12B20 charge. But fundamentally, the findings in the OIP is that there was misleading information. And so, you know, it depends on what's being discussed internally at the entities and the people involved, whether people are acting in good faith, facts and circumstances specific.
Let me ask you one last question before we end. Now that we saw the CDC issue its guidelines, no more, you can be, I guess, maskless inside and out. What would be the staff's reaction if council made a request to meet in person on a particular item in the near future? With the representation, you're fully back.
You know, I don't think I don't have that guide. I don't know. I don't know. I think there's going to be a lot of adjustment and a lot of thought that has to go into this. I don't have an answer for you, but we'll find out soon enough, I suppose.
I think it should be yes. If you want to share that with folks. I don't know.
I don't think it's going to move the needle
anyway. What's that?
I said duly noted.
Okay. I don't know what's going to
I agree. I vote in favor of in-person meeting.
Got two now, Ashley and me. All right. I see Bruce has showed up. Thank you so much, Jason, Ashley, and Jennifer. You were wonderful. And Bruce, back to you.
Thank you, Kaz and Ashley, Jason, Jennifer. Terrific job. We really appreciate you joining us and giving us your insights. Hopefully, there won't be another COVID panel next year, right? We'll be done with this now.
Done with it. No more.
Our next panel is on whistleblowers. You won't want to miss that one. It starts at 4:40 p.m. Pacific, so we'll see you back here in 5 minutes. Thank you.